Viewer advisory. This story contains descriptions of violence and sexual offenses against a minor. Discretion is advised. According to the law, killing someone is a crime. There are specific exceptions, like cases of self-defense. But when the justice system seems to fall short in detriment of the weakest, some people might ask themselves, is the law enough? On March 28, 2026, the remains of Colie Lee Daniel, a convicted sex offender, were found in a suitcase at a ghost neighborhood in Palm Bay, Florida. Among the body parts, an Amazon package was also found addressed to a 19-year-old named Lucas Sander Jones. This is a developing case. Lucas Sander Jones is presumed innocent until proven guilty in a court of law. All facts below come from public court records and police affidavits. Now, according to the arrest affidavit, Jones killed Daniel with a baseball bat, dismembered the body with a cleaver, a saw, and a knife, and had printed a list of nearby registered sex offenders. Jones has been charged with murder, but he has not entered a plea. This case has divided opinion in ways that feel uncomfortable to sit with, and we will explore exactly this in this 10-minute brief. The timeline as laid out in the arrest affidavit filed by Palm Bay Detective H. Branch is precise. On March 20, 2026, at approximately 5:32 p.m., Colie Lee Daniel arrived at Jones's home on Watson Drive in Indiana. Though until now, no motive as to why he went there has been cleared. Surveillance footage captured him entering. He was never seen leaving. That evening, Daniel's parents arrived looking for their son. Jones answered the door, claimed Daniel was inside, and refused to allow the family or responding Indiana police officers to enter. Jones's girlfriend, Michelle Burrows, arrived shortly after. Inside, she saw black spray paint on the hallway walls, blood on the floor and tile grout, and blood on Jones's jeans. Burrows stated to the police that Jones told her directly, "I killed somebody and cut him up." Still, according to Burrows' accounts to the police, Jones named the victim and described using a baseball bat, then a cleaver, a saw, and a knife. The remains were placed in suitcases and storage bins, transported to the compound, and dumped. Daniel was reported missing by his mother on March 22. 6 days later, vultures led police to the suitcases. Jones was initially arrested on March 29 on charges of tampering with evidence and improper disposal of human remains. He posted a $7,500 bond and was briefly released. Prosecutors upgraded the charge to murder on April 1st. He is now held without bond, with an arraignment set for April 21. His attorney has not commented on the record. Jones, as of today, hasn't admitted of being guilty or innocent until proven otherwise. The details of Daniel's conviction are central to understanding why this case has produced the reaction it has. According to court records, Daniel was found guilty on October 29, 2018 of lewd or lascivious battery on a victim between 12 and 15 years of age. In simple terms, the 2017 Indiana police arrest affidavit states that Daniel, then 19, approached a 12-year-old boy, took him behind a closed business, restrained him, and sexually assaulted him. The boy cried and ran home. In his recorded interview with detectives, Daniel admitted having strong sexual urges toward minors and possessing nude images of multiple underage students. His sentence: 36 daytime served and probation. He was placed in the Florida Sex Offender Registry and remained on it at the time of his death, living roughly 1 mile from Jones. Daniel had served his sentence and remained compliant with the Florida Sex Offender Registry at the time of his death. Those two facts, the nature of the offense and the length of the sentence, are what have driven the most polarized reactions to this case. For some, they are evidence of a system that failed to protect the public. For others, Daniel had served his legal sentence and was entitled to live without being executed in his neighbor's house. The Jones case did not arrive in isolation. 1 month before Jones was arrested, the country had been processing a case in the same emotional space that generated a similar debate. On February 15, 2026, former UFC heavyweight champion Cain Velasquez was released on parole from California State Prison, having served approximately 1 year of a 5-year sentence for attempted murder. Why? Because in February 2022, Velasquez had chased a vehicle carrying a man he believed had sexually molested his 4-year-old son. After chasing the man, Velasquez opened fire. The shot struck the man's stepfather, causing non-life-threatening injuries. Velasquez entered a no-contest plea to charges including attempted first-degree murder. Prosecutors sought 30 years to life. The sentencing judge, visibly in tears, handed down 5 years. With time served, Velasquez was paroled in roughly 1 year. The public reception of the two cases reveals a tension worth naming. Velasquez's case drew widespread sympathy. A father, a young child, and a direct alleged abuser. Both cases raise the same difficult question. What happens when the system appears to fail those who need protection the most? The Jones case draws more ambivalence. A 19-year-old with no documented personal connection to the victim, a premeditated killing, and a printed list with complementary evidence that he was intending to kill more. And yet, both cases are being processed through the same framework. What do you do when the system has failed to protect the vulnerable? When Jones's arrest became public, the reaction divided sharply and almost immediately. On one side, thousands of online comments described Jones as having delivered justice the courts refused to deliver. The 36-day sentence Daniel received in 2017 was treated as Exhibit A against a system that does not take child sexual abuse seriously. The printed list was read as proof of moral purpose rather than evidence of premeditation. On the other side, it has been argued that Jones had appointed himself judge, jury, and executioner over a man who had no idea he was being targeted, with no due process. Disclaimer: Big Picture does not endorse or encourage any form of vigilantism or extrajudicial violence. These two positions reflect real tensions in our justice system. The rule of law depends on the state holding a monopoly of legitimate violence. At the same time, public frustration with sentencing outcomes in child sex offense cases is well documented. Sex offender registries were created to give communities important information. What they were never designed to be is a hit list. The sentencing picture in child sex offense cases is genuinely uneven. Studies show high variation in outcomes based on jurisdiction and prosecutorial discretion. Daniel's 36 days for a contact offense against a 12-year-old sits at the low end of that spectrum, and it is a problem. What is not a legitimate answer to that policy problem is the clubbing. But the fact that individuals are increasingly going after that is a signal that policymakers cannot afford to ignore. Lucas Jones is awaiting trial, and, as we said, he has not entered a plea. Disclaimer: Jones is presumed innocent until proven guilty. Big Picture does not endorse or encourage vigilantism in any form. And many can conjure up thousands of solutions. Others might defend the law wholeheartedly and say the law gave out justice, even if you didn't like it personally. Others might believe that the law fell short and someone stepped in. The most objective solution, rather than vigilantes, is a justice system that takes child sexual abuse to the correct extent of the law, so vigilantism becomes unnecessary in people's heads. Until the justice system consistently delivers sentences that the public views as proportionate to the harm caused to children, cases like this will continue to happen. But we want to know your opinion, so drop a comment below. And if you like this video, give it a thumbs up and subscribe to get more analyses like this one. And if you want to stay ahead of our releases, click the link in the description or scan the QR code on the screen. You won't want to miss this exclusive chance. See you in our next 10-minute brief.